Hello everyone, this is Paulami Saha. I'm a second year student pursuing my law degree from School of Law and Justice, Adamas University. Anything that curtails or impairs the freedom of limits of the judicial proceedings is known to be as the contempt of court. Today we are going to have an informational session with our very own professor from Adamas University, School of Law and Justice, Ms. Sarbani Bhowmik, on the topic of contempt of court with relevance to India. Dear audience, let me introduce Ms. Bhowmik to you. Ms. Bhowmik has completed her BA LLB Honours from Department of Law, Hazra Campus, Calcutta University. Thereafter, she has pursued her LLM in Business Law from Amity University, Kolkata. She pursued double LLM in Constitutional and Administrative Law from Department of Law, Hazra Campus, University of Kolkata. She qualified West Bengal State Eligibility Test in 2019 and she is currently pursuing her PhD from Adamas University. Hello, ma'am. Welcome to our session.
Thank you, Paulami. Thank you for the delightful introduction and also good afternoon to you. Okay, so I'm all here. So you can ask me whatever you want to ask me.
Yes, ma'am. So, ma'am, firstly, what made you interested in law?
Well, this is not a very tough question, but still, uh, so being a child of a family where I had normally seen doctors and engineers, I somewhere felt that legal awareness is extremely important. Not only for myself, but also for the family as well as the society as well. It's very important that we know the law of the land. I think you are aware of the legal maxim, ignorantia juris non excusat, which means that ignorance of law is not excuse. So, yes. So, apart from this, law as a discipline, as it also helps us to apply logic and also act judiciously. So this is what actually have persuaded me to opt for legal studies. And I also sometimes I used to find it interesting when people used to ask me like small legal remedies. And I'm pretty sure that by now, if not many, but few of your family members have already asking you such remedies, isn't it?
So that is true, ma'am. That is
yes.
true.
So that kind of spotlight is always on. So this is what I really like about law.
Yes, ma'am. So, starting with our topic today, what exactly do we mean by contempt of court?
If you ask me in simple words, contempt of court basically means any kind of disrespect or disobedience towards the court or any kind of interference or disruption in the legal proceeding. And technically, under Section 2A of Contempt of Court Act 1971, it includes both civil and criminal contempt. Civil contempt actually includes any kind of disobedience to court judgment, decree, or orders, whereas criminal contempt includes any kind of publication, be it written or spoken, that scandalizes or prejudices the authority of the court, or any kind of interference into the process of administration of justice. So that is actually what we exactly mean by contempt.
All right. Ma'am, the next question is the contempt of court proceedings restricting the freedom of speech and expression of the media? What is your opinion?
No, it is actually not restricting the freedom of media. If we go through Article 19(2) of Indian Constitution, you will find that contempt of court is itself one of the reasonable restriction to freedom of speech and expression. Okay, and that's why it is not at all justified to say that it is curtailing the freedom of speech and expression. Okay, and most importantly, it is very pertinent to know that media is not being restricted from publishing any true fact or which is expressly visible in public record. It just prejudices, if it prejudices any kind of law and order, it is when it is being restricted. Okay, so under no circumstances, it must not prejudice any kind of law and order. Otherwise, if the media is actually working with an honest intent, or it is actually publishing any kind of public record, in that case, media is not curtailed. Right. So under such circumstances, I won't say that it is actually restricting the freedom of speech and expression. I can give you two such examples where the freedom of press has been upheld and it has not been said that there was any kind of contempt of court. Soon after, in ADM Jambalpur versus Shikavan Shukla case, there were two such cases of contempt of court that was filed. One stated that there was some kind of derogatory remark regarding the integrity of the judges, and another was related to the appointment of the Chief Justice of India on basis of seniority. So, a separate constitutional bench sat to decide both the cases, and they found that there were no such contempt of court. Okay, so so basically, it actually clearly proves that when freedom of press is needed, okay, it has been given equal importance, and it has been allowed. Again, in a recent case, in Mr. Prashant Bhushan case, we have seen that he has tweeted some kind of derogatory remark against
Yes.
the Honorable Supreme Court, and contempt of court case was initiated against him. And very after that, he very quickly he had actually tweeted another apology, like clarifying that he had no such intent to disrespect the Honorable Chief Justice. So basically, it actually depends upon the merits of the case, right? Again, in my opinion, contempt of court is not prejudicing our right to freedom of press or speech or expression.
Right, right. Ma'am, what are the exact guidelines that the media shall follow with respect to privacy and the respect of the code of proceedings?
Okay. Now, right to privacy is itself a fundamental right. Okay.
True.
So that's why I would say that there has to be a reasonable line beyond which nobody can be allowed to go. Okay. So
Yes.
there is always a private space and it must always be respected. And to this, we have a very renowned and a very landmark case, which is commonly known as the Auto Shankar case. And the name of the case is R. Rajagopal versus State of Tamil Nadu. Right. So in this particular case, the Honorable Supreme Court has clearly pointed out the importance of striking a balance between freedom of speech and expression and the freedom of speech, freedom of praise and right to privacy. Okay, so it has clearly pointed out that no such prior restriction is being imposed on any kind of publication. Okay, they are allowed to publish any kind of public record. But if the media wants to go beyond that line, in that case, they have to take the permission of the concerned person. Otherwise, it will be an infringement to right to privacy. So somewhere we need to strike a balance between the freedom of press and the right to privacy. Okay. So, and most importantly, when all our fundamental rights you see are all interrelated. So that's why that is most importantly, we have this reasonable restriction, and contempt of court is one of the reasonable restriction, and which we must always respect. So that is my say on right to privacy and freedom of press.
Rightly said, ma'am. Ma'am, as you know, in the Kathua gang rape case 2018, Media House revealed the identity of the victim. How much it is justified for the media to do so? Please comment
Of
on that.
course not. Of course not. It is not at all justified. And as soon as this particular word rape comes to my ears, I find it very inhuman. Not only inhuman, it is very disrespectful and derogatory. And revealing the identity of a victim is far more inhuman. No, see, if we talk about law, Section 23 of POCSO Act as well as in 228A of IPC, it clearly talks that the victims of the sexual offences, the identity of the victims of the sexual offences cannot be revealed. Okay, it is totally punishable offense, right? But if we talk about jurisprudence also, it is also clearly there that even the dead has the right to dignity. Even though the particular person is not alive to give the consent, but we have to respect the dead. Even they have the dignity, right? It sometimes it can be published, like we have seen in Delhi gang rape case. The identity of the girl was revealed, but that was only when the media had received the consent of the king, right? And without the consent, And even if I won't say that only because there was a consent they have revealed, but to my opinion, under no such circumstances, be there is a consent or be there is no such consent, the name or the identity of the victim must be never revealed. Be it a dead or be alive, I strongly object to that.
Yes,
I just let me just ask you a simple question, right? Suppose I tell you or I narrate two such rape cases, okay, two distinct rape cases. In one, I'm going to tell you the name of the victim, and in another, I'm not going to tell you the name of the victim. Now, please tell me, like, is it going to change your emotion or views regarding that? Like,
no,
will it like appeal it more if I reveal the name, and it will not appeal you if I do not tell you the name? Is it that
no,
rape
ma'am.
itself? Yes, rape itself is a heinous crime. There is nothing lying in the name. But think about the kings of that particular victim, like particular victim or the family members of the victim. Like every time in the newspaper or in TV channel, especially in this Kathua gang rape case, the identity, the photo of that girl of 8 years was like constantly like showing in media as well as in newspaper. The kin of this particular victim were not pretty much like legally enlightened to comment on that. Even they did not know that there is something like right to privacy, or they were not aware of the legal framework that it must not be revealed or not, whether they have given the consent or not, whether it is appropriate or not. They are not aware of such legal frameworks, right? So maybe they have given the consent because it is them who have actually given the photograph, right? But just think about the pain when you see the picture of the particular person again and again in the media, how much pain it is like being added to that particular family, right? So I believe it must not be revealed at all, and it's a highly inhuman practice if we reveal the names of the victims, right?
Ma'am.
Let's not increase the pain, right? Let's not increase it.
Yes, ma'am. Ma'am, in the light of the legal framework in United Kingdom, is it relevant in India?
See, I'm aware of this fact that UK has already abolished the cases of offences related to contempt of court. But it is also very pertinent to note that the last case of contempt of court in UK was reported in the year 1931. Okay. And in India, as far as my little knowledge is concerned, a number of pending cases on civil contempt of court is approximately 1 lakh, and around 600 approximately in case of criminal contempt of court. So, since you know the statistics now, so I believe like this is not the right time for India to abolish the same, right? Because it's 1 lakh approximately and 600 approximately, huge number.
Indeed, indeed.
Yes.
Okay, ma'am. This session was really very informational, and I would like to conclude the session with the last question. As the fourth pillar of democracy, what, in your opinion, is the duty of media to provide information without any ambiguity?
See, it has always been acknowledged that freedom of press and media is the fourth pillar, one of the strongest and the fourth pillar of democracy. And the media will keep on playing the role of traditional watchdog, right? As well as a crucial instrument of accountability to counter corruption and especially promoting free and public opinion. So, in my opinion, this is about freedom of speech and its significance.
Indeed. This was really a very knowledgeable session, ma'am. Thank you so much for coming and sharing your knowledge with us. It has been really a great opportunity to like interview you, ma'am. Thank you so much for giving your time, ma'am.
Thank you so much, Paulami, and looking forward for more such interactive sessions. And thank you and have a good day.
Thank you, ma'am. Absolutely. Thank you, ma'am. Have a good day, ma'am.